So imagine for a second that a physical retail store just locked its front doors to prevent you from leaving without buying something.
Oh, the owners would be arrested immediately.
Right. I mean, the police would show up, there'd be this massive public outcry, and the business would be shut down. Period.
Yeah, you can't literally trap people.
Exactly. So why do we, completely accept it when a website does the exact same thing to us?
It's a huge double standard, honestly.
It really is. Welcome to today's deep dive, by the way, because we spend a massive portion of our lives navigating these digital platforms, constantly making choices. We click links, we add items to our carts, sign up for services.
Operating under the assumption that we are the ones in the driver's seat.
Right. But then you hit that friction. You try to, cancel a subscription or close out of a pop-up ad, and suddenly the steering wheel just locks up.
Yeah, the classic hidden no thanks button.
Or there's that giant ticking countdown timer telling you that you are about to lose a deal forever. It ceases to be a choice. It instantly becomes a trap.
Well, the psychological weight of that moment is actually profound. And UX designers completely know it. They are weaponizing cognitive load.
Weaponizing cognitive load. That is a great way to put it.
Yeah, because when you are staring at a screen, feeling that mild panic or just that deep, exhausting frustration, you're experiencing a highly intentional architecture.
Like the website is actively working against your intentions to fatigue you into compliance.
Exactly. It's not a glitch, right? It's not a poor layout. It is a calculated behavioral engineering tactic designed to basically wear down your decision-making faculties until you just give in and click accept.
Which brings us to our mission today, because just yesterday, Indian regulators dropped a seriously heavy hammer on that exact type of behavioral engineering.
Finally.
Yeah, the authorities are finally treating this toxic website design not just as a daily nuisance, but as a prosecutable legal offense.
They're putting a very literal price tag on digital manipulation.
They really are. And for our sources today, we're pulling from an official order from the Chief Commissioner of the Central Consumer Protection Authority of India, the CCPAI.
A very significant document.
Huge. And alongside that, we are looking at the accompanying Press Information Bureau release and also this really sharp analytical piece from Navi.org that takes this into some pretty wild data privacy territory.
The core issue running through all these documents is that the digital floor plan is basically being brought up to a new legal building code.
I like that, a legal building code.
Right, because for years, the frustration of being trapped in a digital maze was largely ignored by the law. It was seen as just a marketing tactic.
Annoying, but legal.
Exactly. But now the CCPAI is stepping in and explicitly stating that the digital environment must allow for clear, unmanipulated consumer choice. They're actively regulating the physics of the digital space you inhabit.
So let's look at the specific targets of this enforcement, because the CCPAI didn't just issue some vague warning. They penalized two massive recognizable entities.
Two heavy hitters. Yeah. We are talking about Physics Wallah Limited, which is an absolute giant in the educational technology space, and McAfee Software India Private Limited.
One of the most recognized names in antivirus and cybersecurity.
Right. Two companies operating in completely different sectors, yet both were just penalized for relying on the exact same manipulative tactics.
And the technical term the CCPAI order uses for those tactics is dark patterns.
Dark patterns.
Yeah, and the regulator actually handed down civil fines to both. Physics Wallah was hit with a penalty of 5 lakh rupees, and McAfee was fined 1 lakh rupees.
Okay, but it wasn't just the money, right?
No, not at all. Beyond the monetary penalty, the CCPAI issued a strict, immediate directive mandating that both companies completely remove these practices from their platforms.
Immediate removal.
Yep.
That's a big deal.
And the wording in the order is the really crucial part here. The CCPAI didn't penalize them for false advertising in the traditional sense.
Right.
They penalized them because these dark patterns prevented consumers from making informed choices by subjecting them to, quote, pressure or manipulation, which fundamentally changes how we view internet marketing. I mean, I want to make sure we really grasp the mechanics of what the source means by preventing informed choice through pressure.
Yeah, let's break that down.
It's like, okay, it's like trying to unsubscribe from a magazine, but the cancel button is printed in white ink on a white background.
Oh, that's infuriating.
Right. And every time you try to leave the room, the physical door handle changes its shape. It's just this structural friction.
Yes.
The company isn't outright lying about what the magazine costs. They are just making the process of saying no so exhausting and confusing that your brain eventually just gives up.
That structural friction is the perfect way to understand the evolution of consumer protection law here.
How so?
Well, historically, regulatory bodies focused on the product itself, right? Like, did the company lie about the software features? Did they make a false claim about the educational course curriculum?
Basically, is the product a scam?
It's exactly. Traditional false advertising is essentially a deceptive billboard outside the store. But the CCPAI is moving past the billboard and inspecting the architecture of the store itself.
Wow. Okay.
Yeah, they're declaring that if the environment you construct is fundamentally manipulative, the product you are selling almost doesn't matter. The manipulation itself is the legal violation.
But this brings up a massive discrepancy that jumped out at me while I was looking through the facts of the CCPAI order.
The fine amounts.
Yes. We are talking about a 5 lakh fine for Physics Wallah and a 1 lakh fine for McAfee. These are huge tech corporations. I mean, they generate massive revenues. Yeah. Is a maximum 5 lakh fine genuinely supposed to deter them? Because, I mean, if I am a tech executive running a multi-million-dollar platform, a 5 lakh fine is just the cost of doing business.
That's pocket change.
It's a minor speeding ticket for a race car driver. It almost seems like it would be more profitable to just, keep using the dark patterns and pay the tiny fine whenever the CCPAI comes knocking.
I get that.
Yeah.
But the perceived leniency is actually a very deliberate strategic move by the regulator.
Really? A strategy?
Yes, but to see why, we have to look at the massive legal arsenal they built to make this move.
Yeah.
The CCPII didn't just invent these fines out of nowhere.
Right, there's a framework.
Exactly.
Right.
This enforcement is backed by a 3-layered framework of digital regulation. You have the overarching Consumer Protection Act of 2019, which is like the foundation.
Okay, the CPA 2019.
Then on top of that, you have the Consumer Protection e-commerce rules of 2020. And the sharpest tool they have is the highly specific guidelines for prevention and regulation of dark patterns.
And those were just rolled out recently, right?
Yes, just in 2023.
Okay, so they have this robust, multi-layered rule book, but they still only issued a minor civil fine. I mean, the documents note they could have gone up to 10 lakh under the civil provisions alone, but they stopped at 5 and 1.
Right.
So why build this massive legal machinery if you are basically going to hold back on the punishment?
Because the civil fines are just the surface layer. The documents reveal that the CCPAI actually has access to a legal nuclear option under the Consumer Protection Act of 2019.
The nuclear option.
Specifically Section 89.
Yeah.
And Section 89 doesn't deal with civil fines. It deals with criminal prosecution.
Okay, yes. This is where the source material gets genuinely intense.
It's terrifying for a corporation.
Because when you look at the text for Section 89, it states that any manufacturer or service provider who causes a false or misleading advertisement to be made, which is prejudicial to the interest of consumers, triggers the criminal code.
Right. Criminal, not civil.
And for a first offense, we were talking about imprisonment for a term which may extend to 2 years, plus a fine that can reach 10 lakh rupees.
Actual prison time. And the escalation for repeat offenders is even more severe.
What happens on strike 2?
For every subsequent offense after that first strike, the penalty jumps to imprisonment for a term which may extend to 5 years and a fine that can reach 50 lakh.
Furthermore, and this is huge, the CCPAI possesses the administrative power to entirely bar the service from operating for up to 2 years.
Okay, wait, let's just pause on that for a second. Because a 2-year operational ban for a digital business isn't just a penalty.
No, it's a death sentence.
It is an execution.
Yeah.
If a cloud-based antivirus software or an online education portal goes completely dark for 2 years, the company ceases to exist.
Absolutely.
All their subscribers leave, their revenue goes to zero, and their market share is instantly swallowed by competitors.
But he'd never recover.
But that circles right back to my original frustration. If you have the power to shut a company down for 2 years and put executives in prison for 5 years, why on earth are we handing out 1 lakh civil fines?
Okay, the strategy comes down to 2 things: the burden of proof and the speed of enforcement.
Speed, okay.
Remember, the specific guidelines for dark patterns were only codified in 2023. This is entirely new regulatory territory for the Indian legal system.
Right, they're testing the waters. Exactly. If the CCPAI had immediately invoked Section 89 and pursued criminal charges against McAfee or Physics Wallah, they would have triggered a multi-year legal war.
Oh, I see.
Criminal prosecution requires a massive burden of proof. The companies would have deployed armies of corporate lawyers to tie the enforcement up in litigation for half a decade.
Just arguing over the technical definition of a digital countdown timer.
Exactly. So by keeping it civil, they avoid the quicksand of the court system.
They establish immediate, undeniable precedent.
Yes. The CCPAI chose to issue a swift civil fine to officially put on the public record that dark patterns are a direct violation of the law.
They're proving that the 2023 guidelines actually have practical teeth.
They have drawn a very clear line in the sand without getting bogged down in years of court battles.
Which transforms that small fine from a minor tax into a foundational legal warning label. Like they're building the jurisdictional muscle right now.
That's a great way to look at it.
So if Physics Wallah, McAfee, or any other platform watching this decides to reoffend, they can't claim ignorance anymore.
Nope.
The CCPAI now has the established baseline to say, look, we gave you a warning. We used the civil options. Now we are opening the Section 89 criminal playbook.
And the signaling effect is the true victory here. The regulator is demonstrating to the entire corporate sector that the Consumer Protection Act of 2019 is highly adaptable to modern digital manipulation.
This raises a much bigger question, though, because the Navi.org analytical piece in our stack points out that this enforcement isn't just about consumer rights.
No, it goes way beyond that.
Yeah, they call this a good case study because it bridges consumer protection with something much deeper. I mean, if I am forced into clicking a button just to escape a pop-up maze, does my click actually count as legal consent to hand over my personal data?
And the intersection of those two concepts is where the legal landscape completely shifts.
Tell me more about that.
Well, the Navi.org analysis connects the use of dark patterns directly to the DPDPA 2023.
Which is the Digital Personal Data Protection Act.
Correct. We are moving from how you were treated as a shopper to how your fundamental identity is protected on the internet.
It's a huge leap.
It is. Under the DPDPA 2023, the law stops referring to you merely as a consumer and elevates your legal status to a data principal.
Data principal, that carries so much more weight than just user or shopper.
It does.
It almost implies like ownership.
Because it formally recognizes that your personal data is an extension of your personhood, not just a byproduct of your online activities.
Yes.
As a data principal, you are granted fundamental rights regarding how your information is harvested and processed.
And the vital insight from that Navi.org piece is that the DPDPA explicitly recognizes the use of dark patterns as a direct threat to those exact rights.
Yes. It falls under the mandate for the prevention of harm to data principles.
So wait, the law is officially classifying hostile website design as a statutory risk.
Exactly.
It is a categorized risk under the DPDPA that platforms are legally required to mitigate.
Think about the mechanics of modern data harvesting for a second. Almost every action you take on a website, every click, every swipe, every menu you open involves the transfer of data.
Right, they track everything.
And platforms need your legal consent to process that information. But if the architecture of the website uses dark patterns to coerce that action, the foundation of that consent crumbles.
Because it's not real consent.
Exactly. If a platform psychologically fatigues you into clicking accept on a confusing privacy menu, they're basically extracting your data under duress.
The structural friction invalidates the legal agreement.
Totally invalidates it.
Going back to our metaphor of the shifting door handles and the white ink, if I finally find the exit, but to open the door I have to unknowingly sign over my browsing history, my consent is entirely fabricated by the environment.
It is coerced compliance, not willing agreement.
And the DPDPA 2023 recognizes that vulnerability. It acknowledges that the data principle is susceptible to psychological manipulation by platform architecture.
Which is why this CCPAI enforcement against Physics Wallah and McAfee is such a landmark moment.
It proves that the regulatory web is tightening from two completely different directions.
Exactly. Companies aren't just risking a consumer protection fine for tricky marketing anymore.
Right. By deploying dark patterns, they are carrying a recognized statutory legal risk under sweeping data protection laws.
They are violating both your rights as a shopper and your rights as a data principal simultaneously.
It is a massive paradigm shift for the internet. The authorities are retroactively forcing the entire digital ecosystem up to code.
It really is incredible to watch.
It's fascinating how a seemingly minor 1 lakh or 5 lakh fine holds so much underlying weight. I mean, we started today looking at a couple of small penalties for annoying website design, but peeling back the layers revealed the terrifying specter of Section 89
2-year operational blackouts and actual prison sentences.
for tech executives. And from there, we crossed into the absolute frontier of digital law with the DPDPA 2023, where your psychological agency on a website is legally protected as a fundamental privacy right.
The implications for the listener, for the average person, are deeply empowering, honestly.
How so?
Well, we have all internalized that digital claustrophobia as just a normal part of being online, right?
Definitely. Just part of the internet.
But the takeaway from these frameworks is that your frustration is actually legally valid.
That's a great point.
The next time you're trying to navigate a platform and you feel rushed by a fake timer or pressured by obscured buttons, you are not just experiencing bad design.
No, you are encountering a dark pattern.
Exactly. It is a classified risk or recognized harm, and Indian law is actively building the machinery to prosecute the companies that use them against you.
We all know the feeling of hitting that friction, of having the digital steering wheel lock up on us.
We've all been there.
The CCPAI has finally put a legal name to that trap, and they've put a preliminary price on setting it. They chose to fire a warning shot this time, intentionally keeping the 2-year service bans and the prison sentences of Section 89 locked away in the arsenal.
For now, anyway.
For now. But if these minor civil fines don't actually convince massive tech platforms to fundamentally change their architectural behavior, who will be the first company to cross the line and face the full criminal wrath of Section 89?